Let's do a terms and connector search for our parity issue. Now we're starting here. I'm doing this in Westlaw Next, as you can see. But really our starting place should be in our plug. We need to brainstorm search terms and search configurations, permutations, different ways of or different angles of looking for the terms we want in binding precedent out there. We haven't found that binding precedent and we need to figure out how to lasso it in. So over in our plug here, under binding precedent, I created this little chart. So if we go through ITAC here, the issue is whether using the same music but changing the lyrics to a song could still be a parody, especially when the new song really does not comment on the original. Perhaps you can make some very attenuated argument that it does, but I think that would really be stretching. Probably when it pass the giggle test in court. So here are our terms. This is the T of ITAC, our search terms: song, music, lyrics, and parody. And then under A, alternative terms. For song, I came up with word, compilation, tune. For music, notes, bars, measures, tune. Get the idea here. Use synonyms. You deconstruct. You take a bigger concept like music and deconstruct it into smaller concepts. And then lyrics, words, meaning, parody. Another way of saying that is to lampoon. Now the C of ITAC is where you figure out the connectors that you want to use. And using a different connector will give you a different scope of search. So let's go for a bullseye first of all. Let's see if we have a sentence out there in the case law world, in the binding case law world, so cases from the U.S. Supreme Court and the Sixth Circuit, that has all four terms in it: song, music, lyrics, and parody. So to do that, we'll switch back over to Westlaw Next, and I'll write in those terms. Now we make sure our jurisdiction is set to just the binding ones. The U.S. Supreme Court and the Sixth Circuit bind our federal district court in Michigan. And that yields us one case. And it appears to be trusty old Campbell. So that's not good. Let's broaden our search. So how do we broaden our search with different terms here? That's right, you probably figured it out. Change these to P's. So now we're looking for all of these terms within the same paragraph. And that yields us 3 more cases. So we have 4 cases now. So we have Campbell, we have the Campbell from the lower court, and then we have the Campbell from the lower court. Here's from the district court, and here's from the Sixth Circuit Intermediate Court. And then we have an FCC case dealing with television giveaways and not much on parodies. And we should note that this FCC case is from 1954. It is way too old to use. So we need to broaden our search even more. So let's go for song and parody. So I'm going to remove 2 search terms. Okay, and just go with song and parody, but I still want that pretty tight, so I'm going to go within the same sentence. So this nets us 11 cases. Good old Campbell. Okay, Parks is not good because the defendant is not claiming that the song is a parody. Princeton we saw before. It's not dealing with a song, it's dealing with course packs. That's pretty different. This Jerome case is from 1924, way too old, and it has a red flag, which we'll talk about in the next section. That means part of it was reversed. It still may be good for our point, but anyway, it's too old. And we see here a lot of the same cases that we don't like. So we can, of course, play around with our terms and connectors to get the scope right. Going song within the same paragraph as parody, or excuse me, as the same sentence as parody didn't yield anything. So let's go nuts here and use an ampersand, which will give us every case from the Sixth Circuit and the U.S. Supreme Court with the word song and parody somewhere in the document. It may not be in the same sentence or the same paragraph, but somewhere in the document. So this nets us 53 cases. You can see here that we have some old ones, 1975. That's too old. Here's Golan versus Holder. That's that public domain case we've already seen. Sony we've already seen. It's about the videotape. Okay, do you see how we're seeing, no matter how we angle our search here, no matter how we form our search, we're seeing the exact same cases over and over. We use the top search method. We found these cases. We use the word search method. We found these cases. We're not finding anything else. This is a sign that we are hitting bottom, the bottom of the barrel. There's nothing more out there. You get the point. We can do a terms and connector search. You change up the different terms and connectors, and that way you change your scope. And by changing the scope of your search, you change how much you net. Okay, in the next section of the book, we will talk about how to update the cases. You know, once we found a case, we want to make sure that it's still good law. See you then.